Hi, I'm attorney Eric Lewis with Lewis Legal Services in Indianapolis. Today we're going to talk about how to protect your home in the event that you file for bankruptcy and whether there would be any problems in keeping it in filing bankruptcy. Now, as with all my videos, this video is not a substitute for in-person legal advice, and the things I talk about only apply in Indiana. And when it comes to claiming exemptions in bankruptcy, there are many traps that only an experienced professional would recognize. So remember, if in doubt, consult a lawyer. So let's get started. As you may know, when someone files for bankruptcy, there are exemptions that apply that protect a certain dollar amount equivalent of a person's property. If you have a wristwatch and it's worth $20, you claim a $20 exemption, and that stops a court-appointed trustee from selling it for the benefit of your creditors in a bankruptcy proceeding. Most people who file bankruptcy don't lose any property, which may come as a surprise given the doom and gloom stuff that you can find online or hear from the so-called experts. But anyway, there's a certain amount of value in property that you can keep and keep shielded from your creditors in bankruptcy. In this video, I'm going to do a brief walkthrough of how Indiana's Homestead Exemption works in bankruptcy. If you want to skip to the background detail and go right to the examples, skip forward in the video at the mark below. Otherwise, let's get started. Okay, so first you must determine what bankruptcy exemption scheme is applicable to your case. Generally speaking, to use Indiana's exemptions in bankruptcy, you must have continuously lived in Indiana for at least the last 2 years. If not, then you may have to use another set of exemption laws. And I'm not going to get into a lot of detail about that in this video, and that's another reason why you may need to seek in-person legal advice regarding your particular situation. But the Bankruptcy Code is specific about this 2-year requirement, stating that the exemption that applies depends on where you've lived in the 730-day period prior to your bankruptcy being filed. So, if you've owned the real estate for at least 2.5 years prior to your filing of your bankruptcy case, you may be able to use the Indiana Homestead Exemption. Now, does that mean that if it's been less than 2 years, you'll lose your home? No, not necessarily, but you have to look at what set of bankruptcy exemptions may be available to you. There are complex rules in place that dictate what exemptions you can use, and it's possible that you may have to use the exemption law from another state other than Indiana, or possibly even the exemptions provided by federal law. Now, here's one of those traps I was talking about. Even if you've lived in the state for the last 2 years, 2.5 years, there may be a limit on the exemption that you can use if you've acquired the property in the last 3.5 years, literally 1,215 days. So the Bankruptcy Code is riddled with all these specific numbers. Where they come up with some of them, I don't know, but that's what we have to deal with. So last 3.5 years. If it's been within 3.5 years, there's a cap that might apply. And that number is just over $170,000. Now, this rarely comes up in Indiana cases because our state exemption amount is so low. But if the home is owned, say, as tenancy by the entireties, which I'm going to talk about in more detail in a minute here, it could be a potential issue. Okay, so the next thing you need to determine is the type of ownership interest that you have in the property. The key source is the deed to the property. There are quite a few ownership types, but the most common is going to be called what we call fee simple, or some type of joint tenancy. So if you're married and you're both on the deed, it's likely going to be what we call tenancy by the entireties. Now, the concept of tenancy by the entireties, it's an interesting concept in law because it's the fictional idea that the home is owned by you, not as an individual, but rather it's owned by the marriage. So if you're a husband and wife and you buy your home together, it's very likely that your deed was set up as tenancy by the entireties. And we'll talk about that a little bit more here in a minute and about that exemption. The other possibilities of joint ownership are tenancy in common, where you have a divisible interest. So 2 people on the deed owning it 50-50, or 3 people with 1/3 interest each. For example, a joint tenancy usually means that there is a right of survivorship. So a right of survivorship simply means that if one person dies, the house automatically goes to the other person on the deed, or it's split among the other people on the deed if there's multiple people on the deed. So why do these things matter? Well, they're incredibly important in bankruptcy because when you file bankruptcy, you may be able to protect some, all, or none of the interest in the real estate, and it starts with determining the type of ownership. Okay, so at long last, we finally get to the Indiana Homestead Exemption. But wait, I fooled you with that headline. There is no single exemption. Rather, I'm going to talk to you about 3 exceptions. The first is the most common in bankruptcy, and it's provided by Indiana Code Section 3455.10.2, subparagraph C, paragraph 1. The key to using this exemption is that you actually live in the home as your personal family residence, as opposed to it being an investment property or something other than where you lay your head at night. So as you can see, it says real estate or personal property constituting the personal or family residence of the debtor or dependent of the debtor, or estates or rights in that real estate or personal property of not more than $15,000. Now, a quick thing I have to mention about these numbers, and this is true for all the primary bankruptcy exemptions in Indiana, is that under Indiana law, these numbers change every 6 years. So when they wrote this law back in 1998, they added a section about adjusting the numbers every 6 years. So they've changed, in 2004, 2010, 2016, and just recently here in 2022. So beginning March 1st, 2022, the exemption amount here is not $15,000 as written in the law, but it's actually now $22,750. And that will again change in 2028. But all in all, the changes haven't been that drastic over the years, and among the bankruptcy laws for most states, it still remains one of the smallest exemptions in terms of protecting residential real estate in bankruptcy. So some states like Texas and Nevada, Florida, just to name a few, they have very high or some of them even unlimited homestead exemptions. But in Indiana, we have one of the lowest exemption amounts. So if you file bankruptcy, you can protect $22,750 in equity. If you're a couple and you file bankruptcy and you're both on the deed, you can use that exemption and you can double that number to $45,000. Now, remember what I said about tenancy by the entirety. Well, there's a separate exemption for that, and that is an unlimited amount. So as you can see, it reads any interest that the debtor has in real estate held as tenancy by the entireties, meaning that that is entirely exempt from your creditors in bankruptcy and outside of bankruptcy if you lose on a money judgment. So where you have to be careful here is that, one, the property is truly held as husband and wife. So you have to check the deed. And 2, you have to make sure that if you're using this exemption, that there are no jointly held debts. So for example, if only the husband files bankruptcy and the debts in the bankruptcy are only in his name, then the house can't be taken, even in part, by the bankruptcy trustee for the benefit of creditors. That is because the tenancy by the entirety exemption, again, protects the home as an asset of the marriage, not of just the husband. Now, if both the husband and the wife file for bankruptcy, the exemption doesn't work, and you'd have to use the regular homestead exemption that we just talked about, because a bankruptcy trustee could liquidate the property in a joint administration of bankruptcy cases where the husband and wife file together. So if you think that tenancy by the entirety's exemption is applicable, just be careful, make sure you've reviewed everything. All right, so next we have an exemption that doesn't come up as often in the context of real estate, but it does depend on your situation. A lot of people mistakenly refer to this as Indiana's Wildcard Exemption, but Indiana doesn't have a true wildcard exemption. A true wildcard exemption, like some states have, and like there is in the federal bankruptcy exemptions, can be used to apply to anything as a coverall. But Indiana's exemption reads that it just covers other real estate or tangible personal property. And again, this $8,000 number is out of date. The current amount as of March 1st, 2022 is $12,100. But again, This is not a lot of money to protect when you're talking about real estate that's not your personal residence. So something like a rental or an investment property. You can use part of this this particular exemption to cover that amount. Okay, so if you have stuck around this long in the video, welcome to the part where I show you how the exemption actually works in bankruptcy. So let's take an example. Let's say that you have a house that's worth $150,000 current market value. There's a valid mortgage on it with a current balance of $133,000. So that leaves you gross equity of $17,000. Well, under the Homestead exemption, basically that $22,750 exemption entirely covers that equity. So the home would not be sold in bankruptcy. It would be completely protected. Now, what if we were to take these same numbers, but let's increase the market value from 150 to 200. So market value of 200, mortgage balance at 133, your equity is 67,000. Well, under this exemption, you can protect 22,750, so that leaves what we call exposed equity of about $44,250. So what they would figure out is after the cost of sale, after the trustee gets a commission, there would be money left over from this $44,250 to be able to pay the creditors in the bankruptcy. So in this scenario, if the house was worth 200 and that was the balance at 133 on the mortgage, with the Homestead exemption, the house would be sold in bankruptcy for the benefit of the creditors. Okay, so let's take this same market value, 200,000, and look at it under a home that's held by tenancy by the entireties. So in that case, market value 200,000, same thing. Mortgage at 133, equity at 67. Same exact scenario, but different type of home ownership in terms of a husband and wife owning this house together and using the exemption provided by 3455-102C5, which is the tenancy by the entireties exemption. Well, here, because that exemption is unlimited, it would protect the entirety of that equity. Of the exposed equity. So the home would not be sold in bankruptcy. So again, there are some options to consider, but you have to, one, start with the type of ownership and make sure that you're aware of any jointly held debts if you're going to consider using the tenancy by the entireties exemption in Indiana. Okay, well, I hope that presentation was helpful for you and at least providing some guidance in terms of what to expect, what you should be looking at if you own real estate and you're thinking about filing for bankruptcy. So that's it for today. As always, if you have any questions, feel free to reach out, contact my office, leave a comment below, and push that like and subscribe button for me. And as always, thanks for watching.